Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. So today we get to go back to one of my favorite people, Judge Dorow. For those of you who haven't been watching, Judge Dorow is trying the eye drops murder trial. And that's a trial where this person who had at one point been given, apparently been given some eye drops in a drink and it made her sick, decided that that would be, allegedly, that would be the way to get rid of her friend and take her money. That's the state's case in a nutshell. But what's interesting about this is that, again, we have Judge Dorow. There are some interesting contrasts between this trial and the Darrell Brooks trial, and I want to point that out. But before we get there, I want to sort of lay the foundation here, and that is that generally speaking, when you talk to lawyers, they will tell you there are several different kinds of judges. One of the favorite kind of judge that you get when you're a lawyer is the judge who will let you try your case. Now, let you try your case is code for you can get a lot more things into evidence in a case like that than you could with another judge. In other words, the judge exercises his discretion in a less circumscribed way than perhaps other judges. I tried a criminal case again in a court with a judge by the name of O'Malley, a big burly Irishman. That was the case where the prosecution brought a loaded .45 caliber handgun into court and was waving it around, and I pointed out to the judge that the magazine was still in there, and they said, "Oh no, it's unloaded." He dropped the magazine and ejected a live round from the chamber. Not exactly something you want to do if you want to impress a judge, but at least I had the high moral ground of pointing out, hey, that gun's loaded and it's 3 feet away from my client. But the nice thing about Judge O'Malley was he was a judge who would let you try your case. Now, I suspect he probably would not have allowed you to jump up and start slapping the other lawyer, but at least as far as inflicting a barb or making a speaking objection, he didn't really seem to have too much of a trouble with that. Other judges, the judges that are tightly in control of their courtroom, have a much different way of proceeding. Now, in Judge O'Malley's courtroom, you could jump up and say, "Your Honor, I object to that. That's irrelevant. That's not in this case anywhere." And the prosecution then would stand up and say, "Judge, it's completely relevant, this and that." And then the judge would rule in open court. Now, of course, the jury hears all of that. So it can work to your advantage or it can work against you, meaning that if there is an obscure piece of evidence that maybe just doesn't fit real well with the state's case, but they want to get it in anyway, you objecting to it draws attention to it, and it allows the state to explain why they're putting it in and do it all in front of the jury, and that's not a good thing. And the reason it's not a good thing, of course, is because it essentially allows the state to testify, which the state should never do. Now, when we saw Judge Dorow in the Darrell Brooks trial, she really bent over backwards to give him latitude. And although he made a bunch of silly and ridiculous objections and did all these things like, that's not my name, that's not the real person, or whatever that silly objection was that he made about his name throughout the entire trial, which of course is going nowhere at the appellate court other than taking up space in a transcript that the voters and taxpayers of Wisconsin paid for. She let him do it. And the reason she let him do it is because he was pro se and she was sort of giving him some extra, I don't know whether she was giving him extra room to try his case or just giving him extra rope to hang himself. Either way, her failure to rule on certain things that I might have excluded, I don't think it hurt the state's case any. I'll put it that way. Hey folks, please excuse the interruption, but let me ask you if you would, if you haven't already, please subscribe. And if you would, hit that like button and maybe even leave a comment. That tells YouTube that this is a valuable video and they'll refer it to more people.
It helps me out a lot, and I appreciate it. Thank you.
Judge Dorow, though, has a completely different way of handling evidentiary objections. Now, I think a lot of judges default to this, and certainly most judges in federal court, if you ever get to trial, will default to this. And that is, you make an objection, and you either give the shorthand version of the objection, 403, Rule 403, Rule 403 of the Federal Rules of Evidence. Or in 403, of course, is the rule that says something may be relevant, but it's more prejudicial than probative, meaning that it's more likely to cause an emotional reaction than a logical reaction to the value of the evidence. Or you could say Rule 402, that it's essentially irrelevant evidence. It doesn't apply. It doesn't make anything more or less likely to be proved that is material in the case. In other words, it doesn't have the tendency to make a fact more or less probable than it would be without the evidence, and the fact is of consequence or material in determining some issue in the action. These are the kind of shorthand objections that you're allowed to make. What you can't do is jump up and say, "Judge, come on, that is completely irrelevant," because that is a speaking objection. And if the court has directed that there will not be speaking objections, you are stepping on the court's toes, you're ignoring the court's order, and you are engendering the court's wrath against you and likely your client. So what's the number one rule in a courtroom? Don't anger the judge. Some people refer to it a little differently, but don't anger the judge. And if you do so at not only your own peril, because you can be cited for contempt if you disobey court orders, but you're also putting your client's case in peril. So that's one way that you can make the objections. You make a speaking objection for the rule, and then the judge will call a sidebar, and you go up and they turn on the little white noise machine so nobody can hear you two talk. The two lawyers talk, the judge makes a ruling, and on you go. In this clip that we're going to watch here, listen very carefully to the question, listen very carefully to the objection, and then watch how the judge handles this. It'll give you a sense of what it's like to try a case with a judge who is very good with the rules and very much in control of her courtroom.
That's right. I'm just saying I didn't show you that. We didn't talk about that during the break.
No.
Objection, this was entered by defense as Exhibit 626.
That's not the question. The insinuation was that I...
Hold on. Stop. I'm excusing the jury. Be seated. I'm warning both sides. Stop with the speaking objections. It needs to stop now. And we need to be very precise on when we refer to things that I know have happened in the course of this case. And I'm referring to that sidebar. And I'm going to make a record of that right now. And then we'll bring the jury back out after I address this last objection. As it relates to that sidebar, the defense initially objected to receipt of 232. I sustained it, frankly, just because of a foundation. I thought some more questions could be asked, maybe even show the witness the exhibit. But I also know, because we had a hearing in December of last year, specifically on December 9th, where 232 was marked as Exhibit 8. And this witness at that hearing was questioned about that document. And it is fair game for the state to ask him his knowledge about it and what its source is. And number one, he's an expert. He's provided opinions today in front of this jury in forensic toxicology. These are guidelines for opinions and testimony in forensic toxicology. His knowledge of them, or lack thereof, goes directly to his credibility, which this jury will need to determine. I've already referenced he was questioned about it at a prior hearing, again, Exhibit 8. Of course, the defense can redirect, that's appropriate. But then Attorney Kukler accused me of yelling at her in front of the jury, which I was not doing. Out of an abundance of caution, I turned my face away from the jury box and directed it at the back of the courtroom. Was I frustrated? Absolutely. I was frustrated because I knew what this witness had been shown and testified about at that prior hearing, and more importantly, the defense knows about it because it's a transcript that is in this file that was requested by the defense. And so I was frustrated because the defense knows better. And I'm just making this record abundantly clear, I was not yelling. I was in a hushed tone. And I think she said, well, it looks like you're yelling at me. That's why I turned away. And was I frustrated? Absolutely. And I'm also frustrated because of the speaking objections and trying to get information in front of this jury through either making comments or testifying, which, as you both know, that's not how it is properly done. With that, we'll bring the jury back out. If there are any more objections, just say objection. If you want to say relevance, again, 1 or 2 words. I don't want speaking objections.
So did you notice what happened there? The issue that they were talking about initially was, I think, whether or not the lawyer had shown something to the witness over the break time, over the period of time when he wasn't on the stand. And the defense counsel was trying to make it clear that she didn't show him anything in probably the most ham-handed way I've ever seen a lawyer do that. And essentially what she should have done is she should have said, Your Honor, may I approach? She should have come up to the judge and said, Judge, I think what they're insinuating is incorrect. I have denied it, and I'm denying it on the record right now. And I just want to make it clear to the jury that I did not have a conflict. I didn't have anything going on with this witness over the break. But instead, she decides to say, well, I didn't show you that. And she did this like 3 or 4 times. I sort of cut out that part because that's the least interesting part of this entire thing. But then when the objection comes in, she says that the state objects, and then she goes into, well, that's not what I said. What I said was you were insinuating, and of course that's when Judge Dorow hit the wall and jumped up and said, I'm sending the jury out. And yeah, you could tell that the judge is frustrated, but she didn't direct it at anyone. And then when she sat back down, she said, I'm warning both sides, no more speaking objections. And then what was really interesting here is you can sort of get the idea, or at least I think Judge Dorow had the idea, that the defense was trying to pull a fast one here. One of the things that the defense counsel said was this.
Attorney Nikolai's suggestion that I showed you some article about. What was this article about? Because I've never even seen that article.
And here's the part where Judge Dorow comes in and says, no, you know about this exhibit. You've seen this exhibit. We talked about this exhibit back in December. What the heck is wrong with you? And that's why you should never, ever, in front of a jury, say something that's not correct and untrue, because a judge is going to shut you down. And Judge Dorow, she's like one of the best New York hockey goalies I've ever seen. She can stop a shot anytime. And that's what she did. She stopped that right in its tracks and said, no, you know about this. And so then she ends her little colloquy with these folks by saying, no more speaking objections. Short, relevance, materiality, something like that. 1 or 2 words is fine. Long speaking objections won't be tolerated. But here's the other interesting thing. She never ruled on the objection. She never ruled on the objection that was made at that time. And both attorneys seem to have dropped the subject and said, let it go. We're not going to take that objection up. Even though they were clearly talking about a colloquy that occurred at the bench much earlier, and the judge was now making a record of it, the original objection that caused Judge Dorow to send the jury out was never ruled on. which is, again, when you get caught up in the minutia of trial, these are the kinds of things that happen. Now, whose fault is it that she didn't rule on that objection? It's the state's fault because the state made the objection and didn't get a ruling on that objection. Well, that's what I have for you today. Hopefully you have found this interesting, helpful, and useful. And if not, let me know what you need. Let me know what you'd like to hear about. I have my email up there. Feel free to drop me a line and let me know what you think. Thanks again for watching. If you have the opportunity today, go out of your way and do something nice for someone. It'll make you feel great the rest of the weekend. Have a terrific day, and come down here and catch me at the beach next time.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.